questions.
Mr. Park, I've heard the word diversity quite a few times, and I don't have a clue what it means. It seems to mean everything for everyone. And I'd like you first, you did give some examples in your opening remarks, but I'd like you to give us a specific definition of diversity in the context of the University of North Carolina. And I'd also like you to give us a clear idea of exactly what the educational benefits of diversity at the University of North Carolina would be.
Yes, Your Honor. So first, we define diversity the way this court has in its court precedents, which means a broadly diverse set of criteria that extends to all different backgrounds and perspectives and not solely limited to race. And there's a factual finding in this record, PEDAP 113, that there are many different diversity factors that are considered as a greater factor in our admissions process than race. We have a particular interest in recruiting and enrolling rural North Carolinians. In the last incoming class, 4 out of every 10 students who entered the campus doors were from rural North Carolina. 1 out of every 12 students has a military affiliation, including the most veterans on campus since World War II. And so we value diversity of all different kinds and all the ways that people differ in our society. On the educational benefits question, Your Honor, I don't think it's actually disputed here that there are real and meaningful educational benefits that come with diversity of all kinds. SFFA's own expert, this is on JA 546, conceded and agreed enthusiastically, in fact, on the stand, that a racially diverse and a diversity of all kinds leads to, quote, a deeper and richer learning environment, leads to more creative thinking and exchange of ideas, and critically reduced bias between people of different backgrounds and not solely different racial backgrounds.
But you still haven't given me the educational benefits. I didn't go to racially diverse schools, but there were educational benefits. And I'd like you to tell me expressly, when a parent sends a kid to college, that they don't necessarily send them there to have fun or feel good or anything like that. They send them there to learn physics or chemistry or whatever they're studying. So tell me what the educational benefits are.
So there's 3 main buckets, Your Honor, and the first, and I think most pertinent to the question that you asked, is the actual truth-seeking function of learning in a diverse environment. I would direct the court to the Major American Businesses brief, which discusses a whole extensive, rigorous, peer-reviewed literature that diverse groups of people actually perform at a higher level. So the most concrete possible scenario is stock trading. And there are studies that find that racially diverse groups of people making trading decisions perform at a higher level, make more efficient trading decisions. And the mechanism there is that it reduces groupthink and people have longer and more sustained disagreement, and that leads to a more efficient outcome.
Well, I guess I don't put much stock in that because I've heard similar arguments in favor of segregation too. I'd like to go to something different, to deference. In the area of a compelling interest. This court in Grutter did not specifically put the test to Michigan as far as diversity being a compelling interest. I'd like you to explain why in this area of strict scrutiny we have a lower standards. We defer to the accused discriminator. But in the instance of sex discrimination at VMI, the accused discriminator was put to the test, and the court did not defer to VMI, but it deferred to Michigan. Why that difference? And why should you not be treated the way we would treat someone in a Title VII case or a Title VI case and shift the burden to the discriminator to explain the conduct?
Our understanding of the deference that this court provides and the deference that we request is quite limited, Your Honor. We ask for deference in terms of our educational objectives and not the legal question of whether those objectives constitute a compelling interest. And I think that it's pretty clear to see why. I think that is similar to the VMI context. So like I mentioned, we have made it a system-wide priority to.
The court did not defer in VMI.
So I think it did to the extent that it held that the interest in a rigorous military education is an interest that the institution had. And so if UNC decided at a system-wide level to say we're going to completely change our educational mission and make it into an institution like VMI, I think the compelling interest analysis would proceed with that educational objective in mind. But we do not take the position that the compelling interest standard is somehow subject to deference. That's a legal question.